What if I told you the real reason people lose in court and in commerce isn't because the other side is right? It is literally because of something called dishonor. Today I'm going to be exposing the hidden crime of commercial dishonor and why it decides every case and how to use it as leverage. Before we dive into this video, this is not legal advice. This is not financial advice. This is literally for educational purposes only. Do your research. You can research everything that I'm talking about, so please do. Number 2, if you're brand new, hit the like button, hit the subscribe button, tap into the channel because we do post daily content Monday through Friday. Happy Thursday to you guys. Thank you guys once again. All right. The object of today is to talk about the importance of the angle in which I talk about private debt and debt discharge and the aspect of getting them to dishonor and why positioning them to dishonor will actually help you win the case as it pertains to debt discharge. When it comes to debt discharge and private banking, this is the way to win. All right. It's not going to be, I'm not here to tell you about a secret check, a secret formula to be able to wipe away your debt tomorrow. I'm going to give you true processes that's actually going to put them in a position where you shift the burden of proof onto them, have them dishonor, build up a willful non-compliance case, and position yourself to where now they have to adhere to your demands. Simply for the fact that their failure to do their duties is actually a criminal act. You dig what I'm saying? So, thank y'all for watching the video. Let's dive into the video. What is commercial dishonor? Okay, commercial dishonor. Well, first things first, let's talk about what a claim is in commercial law. Okay, a claim is an offer. All right. So, if they claim that you owe a debt, then they essentially sent you an offer. When someone presents you with a bill, lawsuit, or demand, you have a choice either to accept it, reject it with reason, and the rejection has to come with reason, or just stay silent. And staying silent is dishonor. Okay? If you fail to answer or if you argue without substance, you're in dishonor. Commerce is about offers and responses. Dishonor equals default. They don't win because they're right. They win because you just didn't answer in honor. So when we talk about the conditional acceptance process, when we talk about the communication and written communication between you and the debt collector, just like they can dishonor you, you can dishonor them by ignoring their collection letters. And your dishonor is actually what's making you lose every single time. So I'm here to tell you that as long as you communicate back, you can essentially stay in honor, but your communication has to have some level of substance, some level of legal merit, especially if you're going to challenge the debt. You dig what I'm saying? But vice versa. If you send a letter to a company and they decide to ignore you or be silent, then they have dishonored. Here's what the dishonor gives you the opportunity to do. Assume what their response is, but then accepting it and then rejecting it with reason. Most times they reject and they don't even give a reason with actual substance. They just say that you agreed to pay or that you paid, okay? Or you need to pay because that's what you're supposed to do. So let's just talk about the laws that back it up, okay? Now take out your notebook for this part. Also, every single law that I talk about here, if there are any other laws that you want to talk about, drop it in the comment section down below and help the people learn more. Okay, so the first place that I want to first start off is under UCC 1-201. It talks about the aspect of agreement. Distinguished from contract means the bargain of the parties, in fact, as found in their language or inferred from other circumstances, including course of performance, course of dealing, or uses of trade provided in section 1303. Okay. Agreement is formed through offer plus an acceptance. So as soon as someone gives you an offer and it is accepted, then that's when an agreement is formed. Silence or failure to properly respond can be taken as agreement or assent. All right. All of this is broken down in, this is the definition section. So if there's any definitions that you want to learn as it pertains to the UCC, what is Article 2 talks about sales. Okay, so thinking of sales, even them sending you a debt collection letter is a sale. It's an offer. Okay, I'm making an offer that you owe me $10,000. Do you accept? And typically you want to come back and say, I do not accept. All right, so let's move on. Let me not ramble on. Let's go to Article 3. Okay, let's go to UCC Article 3. So when you go to the Article 3, it breaks down the rules of a presentment, okay, and dishonor. Okay, it also talks about the aspect of, or this whole section is geared towards dishonor. So when you're thinking of, when I communicate with the debt collector, I'm sending their presentment. When they do not reply and they're silent, they have dishonored me. I want to know how to put them on notice of their dishonor. So this section is going to tell me how to put them on notice. Okay. What type of presentment and notice of a dishonor can be excused. And then it talks about evidence of dishonor. What will be evidence of it? So the one I want to talk about, and obviously this is the whole entire subsection when it comes to dishonor, if you truly want to know what a dishonor is, but let's just start with presentment. First things first, and I'm not even going to take up too much time, but number one, the rules of the presentment and dishonor for negotiable instruments fall under this entire section in the 5 section, okay? Number one, your presentment is a demand. So if you send a letter, or if they send a letter, whether they are a debt collector or whether you are challenging debt, you have sent in a presentment, okay? A presentment for them to respond to, okay? You have sent an offer or a demand, all right? When it's a demand, that is more of an order. That is not you asking for permission. You dig what I'm saying? But then if we kind of just move forward, let's go to just 505, and it talks about evidence of dishonor, okay? It says the following are admissible as evidence and create a presumption of dishonor of any notice of dishonor, okay? A document regular in form as provided in subsection B, which purport to be a protest, a purported stamp or writing of the drawee, payer, bank, presenting bank, or accompanying instrument stating that an acceptance of the payment has been refused unless the reasons for the refusal are stated and the reasons are not consistent with the dishonor, okay? A book or record of the drawee, payer, bank, collecting bank, kept in usual course of business, which shows dishonor, even if there's no evidence of who made the entry. A protest is a certificate of dishonor made by the United States consul or vice consul or notary public or other person authorized, blase blah. Long story short, these are things that you can use as evidence for dishonor, okay? It's broken down here in the Constitution. Now let's just move on to, this is a pretty long video. So I'm gonna try to move through this fast so we can try to get this under 30 minutes, okay? But then we dive into UCC 3-603. And I repeat these laws because truth is not a persuader. Repetition is. You get what I'm saying? I'll say it again. Truth is not a persuader. Repetition is. And the reason why I repeat these things over and over and over again is because I have many people that come to me that claim they watch all of my videos, but some of the concepts that I will say, it's almost like they still don't believe it, okay? This is why I emphasize the importance of reviewing it as much as possible, especially if you're in the thick of it, okay? Maybe you won't research it as much as me because this is what I do to literally study and share the information to you guys. But these are some of the key laws that's going to help you in a fight against discharge, because what you are challenging is not the money. You are challenging them for their dishonor, okay? So UCC 3-603 says that if a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge. So when we go back to the top and we talk about the aspect of the elements of an agreement or contract, number one, there's an acceptance, either a rejection with reason, or the person stays silent. If they reject it, whether they have a reason or not, or they stay silent, if you have tendered the instrument properly, then there is discharge to the amount of the debt. So someone asks, well, how do I discharge my debt? Well, start sending them letters now, get them to dishonor, get them to refuse your tender for value, and then use that against them. And I could break that down right now, and someone will still say, well, you don't be clear and tell me how to discharge debt, or you overcomplicating, you talk about the laws and all of that. Well, because if I just broke it down and told you, hey, look, all you have to do is send them a conditional acceptance. They are not going to respond back to you. You continue the process of enforcing that demand over 2 or 3 months. If they do not comply or do not respond, you have built a non-compliance case, a dishonor case, okay? A potential bank fraud case, a potential mail or wire fraud case, okay? Because they cannot provide the information that you're going to ask for. And we can look at the GAAP. We can look at all the different accounting principles, all the different financial transparency acts that requires them to provide this information. If they do not provide it, then your obligation is nullified. Forget discharge. Your obligation is nullified and is not enforceable, so they cannot force you to pay, okay? If they violate some of the laws that I'll talk about, okay? More laws that kind of just back up the aspect of dishonor. Okay, if you want to learn more about additional terms and acceptance, okay, that's under UCC 2-207, which essentially is also known as the battle of the forms. If you respond conditionally or with modification, that still counts as a valid response in commerce. It is not silence. Therefore, it's not dishonor. This supports conditional acceptance letters. You are not refusing, you are accepting with conditions. Even if the UCC admits, your acceptance on your terms still binds them. So here's exactly what I'm trying to put to you when it comes to this section. Conditional acceptance, according to this law, allows you to be able to accept terms on conditions. And if those conditions is for you to provide information in order for me to accept the agreement or for me to come to a clear capacity to accept this, I am moving in honor and I am moving in performance. It says it right here under UCC 2-207, okay? But then we can also dive into things like the Federal Rule of Civil Procedure. The Federal Rule of Civil Procedure talks about the general rules of pleading, which is going to break down the rules when you are in court, okay? In court, if a party fails to deny an allegation, it is deemed admitted, okay? So if someone says that you owe $1,000 and you go in court and you didn't even say you don't owe it, even if you feel like you may have taken that money, in court, if you're trying to win, don't tell them you did, okay? So deny the allegation. This is essentially the litigation version of dishonor, okay? If a bank or collector ignores your affidavit, notice, or even parts of your pleading, they have legally admitted it by silence. In court, silence equals confession. Every unanswered point is a win for you, and vice versa for you. Information is so important, especially if you're taking action, because even when you when you don't answer certain points, you have admitted that that was true, okay? So when you say, hey, look, I asked for them to provide the original contract and they did not provide it. Where is the contract? If they don't have a valid reason why they didn't produce the contract, then that's an admitted dishonor. Okay? If I say that you improperly validated and you cannot prove that you have, then you just admitted to a federal crime. Okay? So you don't want to be silenced on both parts, but also at the same time, understand that their silence also plays a big part. So if you ask a specific question, okay, Your Honor, the reason why I made a conditional offer to them is because I felt like because I know that they securitized the loan, okay? Or I felt like they securitized the loan, and under the GAAP, the accounting principles, under any Financial Transparency Act, they are required to show the accounting to the parties that are involved in the account, okay? So when I asked them for the accounting, or I can go to the UCC and I asked for the account statements and the accounting of the account and they didn't provide it to me, I felt like that they was extorting me. I felt like they was trying to commit fraud by not providing information that he or she is required to, okay? And if the lawyer's on the other end like, well, what are they going to say? Well, we shouldn't have to do this. In a court of law, you're just going to lie? Under oath. You don't have to provide me any type of data that in regards to my account and my finances. Okay? So the Federal Rule of Civil Procedure. Okay? Write these down. Another thing I want to talk about is the restatement of second contracts, which talks about silence as acceptance in contracts. This is under the contract law. And then we can talk about the maxims of law. He who does not deny admits. This is a century-old principle that underpins the dishonor doctrine. So goes back way far back. So commercial dishonor isn't abstract. The UCC, the federal court, and contract restatements all agree that they cannot dishonor, they cannot just ignore or be silent or send you a response with no substance. Okay? So this is exactly why I come on this platform, and my whole goal is I don't even talk about, I'll talk about 1099, coupon remittance, promissory notes, but I'm talking about the paperwork and the communication, written communication, and understanding why you can do the things that you can do. Okay? So let's just talk about some real world examples. We talked about some of the laws. I hope you have wrote these laws down so that you can go cross-reference them, do whatever you need to do, throw it in ChatGPT, break it down in plain English, whatever you need to do, because my overall goal is for you guys to actually have success in this, to actually understand, to actually do it in a way that doesn't put you to a detriment or leave you feeling confused. Why did I lose? Well, you lost because you were silent. You lost because you didn't communicate with them. You lost because this, and this. Any person that comes to me and says, well, it didn't work. I tried this. I sent the letters, and then I'll go and ask them, okay, well, what letters did you send them? Well, I sent this letter. And then 6 months went by and they didn't respond. Well, why didn't you enforce their response? Why didn't you tell them that they dishonored? Why didn't you put at the bottom of your letter, and you was very clear and specific, if you do not respond to this, I'm gonna let you know that you have dishonored, and I will take legal action. But you don't take a legal action right away, but you let them know that that could be potentially happening if they continue to ignore you. These are the things that you notate in your letters, and some of the things that the common person who takes templates and sends it in or just wants you to tell them something that'll work tomorrow, those people don't get success because they don't truly understand what it is that they're asking for. They don't even know what they're asking for in their letter. They think this letter is a magic letter that you send to a company and your debt will be discharged. There is no magic letter that you can send to the credit bureau and it'll be discharged. Can someone send you a magic letter and you'll be like, you know what? Damn it, you're right. Especially if you've been getting over on them for the last century. Okay? So let's just talk about some real world examples and let's really speed this up. Okay? The real world examples are debt collectors. You ignore a validation notice and they win by default. Okay? So when you ignore if you ignore them, you default, and vice versa. If you send them a letter and they do not respond, then they have defaulted, or vice versa. However I said it, if they send you a letter and you don't respond, you default. Okay. Court cases. When you argue emotionally instead of conditionally accepting, that also equals dishonor. Okay. For foreclosure, you never demand the note or proper assignment. That is also dishonor. Okay. Contracts. You sign without conditions equals total acceptance and no rebuttal. Okay. Every time you fail to answer properly, the system records you as in dishonor and you lose by default. This is why you have to flip the script onto them, okay? We dishonor them, and this is exactly why we lose. Not because we owe them debt, not because they've actually loaned us money, but because when they said that you allegedly owed them money and you never even replied back and challenged them on that, you have dishonored. So it's almost like it's your obligation and duty to respond back. All right. So why is dishonor hidden in crime? Okay. Banks and collectors count on you to dishonor. They're not going to tell you that dishonoring actually gives them the leverage. That's why they hide it. Courts are structured around this principle, not truth or fairness. Okay. They're really based on procedures and getting the other person to acquiesce and concede. Okay? Dishonor equals consent. They treat it as your agreement to pay, even if the claim is fraudulent. This is why we do what we do, because at any point in time, you can really stop everything that's going on and start to challenge those debt collectors. When they don't tell you about dishonor, this is more of an invisible trick that keeps the debtor roll alive. All right. Dishonor is almost like invisible handcuffs you put on yourself. So always respond back to debt collectors. Whether you're going to send them a letter, pay it, or give them a call and figure out what your next steps are. But you never want to leave things unnoticed, okay? Now, here's how to stay in honor. Always respond. No silence, no ghosting, no ignoring. Do not ignore the debt collectors, okay? And do not allow them to do it to you too. Number 2, always use things like conditional acceptance. Say, I will pay upon proof of claim. It'll keep you in honor while shifting the burden of proof onto them to where now they have to respond to you now, okay? You want to send notices. You want to send debt validation letters regularly to collection agencies. You want to send conditional acceptance letters regularly to creditors. You want to send affidavits, and you want to document every step that you take, okay? Stand calm and not combative. Being in honor is not about arguing. It's about clarity. Hey, look, I just want to get clear, right? I mean, I understand that you guys securitize this loan, and I think that you guys are double dipping. So I just want to get clarity. Can you please provide me the documentation and the accounting? Can you make sure that you still have legal authority to collect on this debt? Because I know that I signed a negotiable instrument, and I'm just now realizing that. So I'm just trying to get clarity to make sure that the contract that I didn't get into was a fraudulent contract that could potentially put me in case of double dipping, or you getting more money or being able to benefit unjustly off of me, okay? That's a valid claim. That's a valid ask. That's not emotional. That's not even combative, okay? So honor doesn't mean submission. It is making them prove their claim. So let's flip the dishonor on them. If they fail to validate the debt, they are in dishonor, okay? If they refuse your tender, they are in dishonor without valid reason. If they don't answer your affidavit, they are in dishonor. Document every single dishonor. When they dishonor, send them a notice of fault, have them default, and then after the default, judgment. Use their dishonor as leverage in a court or a settlement, okay? So if you privately get them to dishonor, you bring up this evidence in court. Hey, look, they dishonored me. I communicated with them over a period of time, and they ignored me, or they purposely provided me wrong information. They failed to provide certain information on purpose, all right? So the system is a game of honor. Flip it and suddenly the dishonor is there. So dishonor is the hidden crime nobody talks about. But once you see it, you understand why banks, collectors, and courts seem to always win against you. They don't win because they're right. They win because you didn't answer. Learn the rules, stay in honor, make them prove every single claim, and down below, tap into the school community, because everything that I talk about here is literally the premise of my school community. Not just on the aspect of the consumer law and understanding how you can communicate with debt collectors, but we talk about the legal merit behind everything that I talk about on the YouTube page. We have monthly calls to where you can be able to do a live Q&A with me and ask me questions directly about your situations. We have resources and templates that you can be able to use as an educational tool so that you can be able to learn on your own, okay? Be able to create your own affidavits, okay? I even put together a GPT in my school community so that people can be able to go, put their problem in, and my personal GPT will literally create a letter for them, okay? So make sure you tap into the school community. It is free for the first 7 days. Once we reach 1,000 members, it is gonna go up and the free trial is up. Now, also at the same time, if you're looking to work with a brand agency, okay, and be mentored by me, tap into that mentorship down below. I don't only just work with brands, but obviously if you're looking to fix your credit and do things like that, tap into that mentorship down below. It's a strict application process, so obviously if you get some answers wrong, you may not be able to get on the phone with me, but that is okay. There are plenty of resources and tools that will fit your situation, so tap into the application down below. Thank y'all for watching the video. I love y'all. Super blessed to have y'all each and every day, and I'll see you on the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9 to 5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.